Welcome to our fifth session of our deep dive series on the Oregon Psilocybin Services Act. My name is Dave Kopilak. I'm a business law attorney at Emerge Law Group, the primary drafter of Oregon Measure 109. We have been doing these webinars every month. We have a very interesting topic today. We're going to be talking about federal law issues and how they relate to Measure 109. We have a great slate of guest speakers. We're going to do things a little bit differently here. And in our prior webinars, there were mainly some Emerge attorneys, and maybe we had one guest speaker or two who would give a 30 or 40-minute presentation. And then we always wanted to have an open-ended, extended Q&A session for the last maybe hour and 15 minutes. Today, my colleague Kathryn and I are going to give a very, very brief presentation. We kind of set the table, and then we're going to have a kind of a roundtable discussion with our guest speakers. We'll still have time for a Q&A session, but that's a slight deviation from our prior sessions. Really quickly, Kathryn Tucker, I'll just introduce some folks. Kathryn Tucker is going to be sort of co-emceeing this with me today. Kathryn is a colleague of mine at Emerge Law Group. She and I co-lead our psychedelics practice group. Kathryn has been specializing in the rights of dying patients for a long time. She was involved in a Measure 109 campaign. Her biography goes on and on with all sorts of achievements, and she can expand on those later. My colleague Casey Homan is a business attorney. I work with Casey all the time. She was on our drafting team for Measure 109, so she and I sat in the room for a long time with some other folks while this thing was being prepared. And so Casey's also going to be kind of emceeing things today with her cat, apparently. And then we have our guest speakers today, which I'll give real brief intros to, but again, they can talk more about themselves in a little bit. Billy Williams, former U.S. Attorney for Oregon, was around through all of the cannabis days and in the early cannabis days, and so had a great experience with that, which could provide some insight into psilocybin. Jodi Avergun is an attorney, former chief of staff for the Drug Enforcement Administration, also former chief of the narcotic and drug section of the U.S. Department of Justice. And her resume just keeps going on and on also. And finally, Rachel Rackow, who is an Oregon physician specializing in end-of-life care, who is eyeballing whether she might be interested in entering Oregon business or becoming a facilitator under Measure 109 and the federal issues that she might encounter if she decides to do that. So Casey, maybe you could for a second give kind of the ground rules like you usually do and the legal disclaimers and all of that. And then Kathryn and I can jump into our short presentation and we can get going.
Sounds good. Thanks, Dave. Hi, everyone. Just want to go over a few housekeeping items before we dive in today. We are recording this event because we may post the speaker presentation portion to our YouTube channel. We don't, however, intend to use any audio or video from the Q&A session, so rest assured that your face, name, voice will not end up online. We do envision this event being conversational in nature. We want it to be a safe space to discuss the Oregon Psilocybin Services Act and any other related ideas. So to that end, we just ask that you please remain open to all viewpoints expressed today and be respectful of others. We don't anticipate having to use the mute function on your microphone, but we do have that ability if we need to. We've allocated 2 hours today for the event so that we can have an extensive and lively Q&A session about federal issues surrounding the PSA, but we have quite a few participants today. So to keep everything as streamlined as possible, when you have questions or comments, the procedure we'd like you to follow is to state that you have a question or comment in the chat box, or if your question or comment is really concise, you can type it out. You can also raise your hand using the reactions button at the bottom of your screen, and I can place you into the queue of questions. I'm going to monitor the questions and comments in the chat box, and I'll call on you to speak during the Q&A session, which, as Dave pointed out, is going to occur after the roundtable discussion with our speakers today. We want to address as many questions and comments as we possibly can, so please be mindful of the time you're taking up. And when you're asking questions, please try to avoid asking fact-specific questions. We're not acting as your attorneys, and we're not giving you any legal advice. We're merely providing information for general educational purposes only. And if you're camera shy or if we run out of time and we can't get to you, feel free to email us. You can reach us at capitalm109@emergelawgroup.com. And I'll put that email address in the chat box later so that you have it handy. And finally, we have our deep dive events on the last Thursday of every month in the year of 2022. So mark your calendars. Our next event is Thursday, June 30th from 4 to 6 p.m. Pacific time. And I will get the presentation going now.
Okay, thanks, Casey. So again, just to sort of set the table here for the discussion, Casey, you can jump to slide 2. There is this thing called the federal government, and there is this thing called the Federal Controlled Substances Act. And under that act, marijuana, psilocybin, and a host of other drugs are unlawful. There's certain exceptions for clinical trials and such, but by and large, if we're talking within the scope of Measure 109, or in fact, if we're talking about cannabis under Oregon's cannabis statute, everything is or will be in violation of federal law. So one might ask, how is this happening? I always found this to be perhaps unique in US history. I don't know, that so many people are violating federal law every day, wide open, and it just happens, and everybody feels relatively safe doing so. And I think it's an amazing sort of thing. So without going through all the history, medical marijuana started in California back in the mid to late 1990s, and Oregon came on board in 1998. There were other states that came on board, but it wasn't until 2012 when Washington and Colorado, via ballot measures, passed their adult use measures. They legalized marijuana, cannabis, essentially for recreational purposes. I think adult use is the preferred term now, but one could say it's recreational. That was probably a game changer. There had been sort of precursors to this thing called the Cole Memo, but when the statutes were passed, I remember the governors of Washington and Colorado weren't really crazy about the ballot measures, and they actually went to DC and asked the federal government, what are you guys going to do about this? And I think they basically said, if you're going to shut us down, you might want to shut us down sooner than later, because we're about to embark on a year-long adventure of rather expensive adventure of making rules and implementing our state law. And if we do go through that whole process and you shut us down, we just wasted a lot of money. So consider, let us know what you're going to do. And of course, the federal government waits until August 29th, 2013. So they took their time a little bit, and they came up with the Cole Memo. And the Cole Memo is an internal document from internal U.S. Department of Justice law enforcement document to U.S. attorneys. There's a whole bunch of U.S. attorneys around the United States, one in Oregon. And the memo said, look, here's what the federal government is really concerned about when it comes to marijuana. We care about kids. We care about gangs and cartels. We care about diversion to other states. We care about violence and firearms and public lands and things like that. But if a state sees it fit to have some sort of legalization, and the rules, the regulatory system around that legalization is robust enough that we think that it's not going to affect the things that we care about, the priorities that we care about, we think that you U.S. attorneys should just kind of let it go. To me, it was kind of a top-down policy. And I remember when I read it 3 times the day it came out, and I viewed it as an unbelievable green light, not even a yellow light, a complete green light for the industry. And I kind of knew that things were going to take off in a massive way from that. Now, that lasted for a good bunch of years, and everybody was chugging along. And Jeff Sessions, who was appointed, who was the Attorney General under President Trump, in January 4th, 2018, as far as I can recall, Billy, it was out of the blue to us, wake up on a Tuesday morning or something, and wham, there's this thing called the Sessions memo. And what does that say? Well, he says, the Cole memo is revoked. The thing that I thought was holding everything together is completely revoked. We don't need it. Department of Justice already has well-established principles that govern prosecutions, and everybody is, free to follow those principles. And that's it. Cole memo is out the window. So I interpreted that to mean that it wasn't going to be a top-down thing anymore. To me, that was kind of Jeff Sessions delegating things to the individual U.S. attorneys and to see what they were going to do. And I suppose they had some discretion. Now, Billy was our U.S. attorney at the time. And do I have that date wrong, Casey? Was the 1/4 date? Was that? Yeah, I got that date wrong. I apologize for that. So Billy, I forget the date of your memo, but it was a few months later when Billy came up with his memo. And Billy, I will say, was a complete thought leader in this regard, as far as individual U.S. attorneys went. Oregon was kind of, the third state to go legal for adult use behind Colorado and Washington. And so we were in the forefront, but Billy himself was in the forefront and basically came up with what we call the Williams memo. I don't know, Billy, if you referred to it like that, but we call it the Williams memo. And it had some, I thought it was always similar to the Cole memo. It had definitely some Oregon specific things to it. I know that at the time there was a big, for example, there was a big overproduction problem in Oregon. There was so much weed being grown. There was so much weed in the pipeline that would obviously be a concern for diversion. How are businesses going to get rid of this stuff? And so Billy came up and gave his 5 enforcement priorities concerning cannabis, but also emphasized that without giving any kind of broad proclamations of immunity, that he would follow the well-established principles and work with the state. And I think by and large, from the industry standpoint, not much changed. But it was good to have that, have something there as to follow up the Sessions memo. And so Billy has left office. As far as I know, the Williams memo has never been rescinded by the U.S. by the district in Oregon. So I suppose it's still there, or maybe it's not there. But one is now, for Measure 109, we have to ask ourselves, will there ever be a Cole memo for Measure 109? Will there ever be a Williams memo or something like it? Or will the federal government come in and shut the whole thing down? Or are we just going to be on our own for a while with no guidance at the whim of some future decision? So that's the criminal side of things. I think Kathryn really quickly is going to go through the DEA registration issue, which we didn't have in cannabis, but which you'll see is an issue, a potential issue for Measure 109.
Yeah, thanks, Dave, and welcome everyone. I have particular interest in the DEA registration issue, partly because my work has focused on the population of patients with advanced illness. And for that population, which of course is a population expected to benefit from psilocybin therapy, because many of the clinical trials have looked at that population and the findings have been quite remarkable. Immediate, substantial, and sustained relief from debilitating anxiety and depression in patients with advanced illness. So it's really exciting to see this palliative care tool soon to be in the palliative care toolbox. But having said that, most of the clinicians who provide care to that population hold registration from the DEA, which is what enables them to handle and prescribe and administer and dispense controlled substances. The really tricky thing, of course, is that psilocybin sits on Schedule 1 of the Federal Controlled Substances Act, which means a clinician cannot have a registration other than for research at this time. Go on ahead to the next slide. So, what's difficult is for clinicians like Dr. Rackow, who's on the call with us today. She is a licensed physician practicing medicine in the state of Oregon. She'll talk a bit about that. She provides care to this population, but she has to keep an eye on her DEA registration remaining viable and valid in order to do her job. So even though she might very much want to participate in the Psilocybin Services Act and make this therapy available to her patients, for whom it would be beneficial, doing so could put her DEA license at risk. And that, of course, could undermine her ability to do her job. So, if the DEA were to take the approach that any DEA registrant who participates under the Psilocybin Services Act will have their license suspended or revoked, that would be very concerning, and it would drive those healthcare providers away from practicing, including psilocybin services in their practice, which would be unfortunate because they're probably the providers that this population of patients would be best served by, because the patients are medically fragile and complicated. So we've given you a few slides, and of course they're available to everyone registered. They kind of tick through what are the grounds for registration, but certainly acting in violation of the Federal Controlled Substances Act would be a significant reason for a DEA registration to be suspended or revoked. So, and I won't go into it on this call, but maybe we'll do a deep dive in future where we do talk about whether we can find a federal safe harbor under the federal and state right to try laws, which is an effort that I've been working on for some time. So with having said that, I think that's probably our last slide there. And we can just really open it to discussion, hear from Dr. Rackow about what's on her mind when she thinks about serving her patients, and hear from these two really expert attorneys who have been inside as prosecutors and who have been in leadership of both DEA and DOJ about what they think. So really excited to open that discussion.
Thanks, Kathryn. And we'll, on our blog, we'll post the short presentation we just went through. I'll correct the date for the Williams memo. So thought we'd start off with Billy. Billy, I'm just, it's not exactly the same. Cannabis back in 2013 is not the same as psilocybin here in 2022, but thought that you could tell us all about your experiences, and it might, aside from being super interesting, might be somewhat insightful and as to what might happen in the future here.
Sure. Thanks, Dave, and I appreciate the opportunity and invitation to participate. And I think it's pretty valuable that these discussions are going on, because those are the kinds of conversations that need to be taking place about issues where you're not going to have agreement and things are new and folks are trying to sort it out, which was my perspective as U.S. Attorney. And I would note, I took over as U.S. Attorney under the Obama administration in the spring of 2015. And so I had obviously the honor to serve in 2 administrations, and 2 administrations at DOJ under AG Holder and then AG Lynch, and then AG Sessions, Barr, Whitaker in between as acting AG, and then finally under Monty Wilkinson, who was the acting AG, who took over in early January of 2021. But my approach, you know, when the Cole memo came into play, I was chief of the criminal division, so I was supervising all the criminal AUSAs in our 3 offices in Oregon. And actually prior to that was what was known as the Ogden memo, the former deputy attorney general that addressed medicinal marijuana in states where it had been legalized. And then of course the Sessions memo. And when that came out, I was actually painting a room at home in my house, and my phone started ringing off the hook, asking what's going to happen. And my response was simple. I wasn't going to overreact. I was going to see if I could find out more information on the change and what it meant. But I ultimately, as I read the Sessions memo, took it to me as an opportunity to develop our district policy. And in order to do that, I felt the need to ask for a summit of all the stakeholders. And I will tell you, lots of people thought it was crazy to ask for that summit, but we did it anyway, because I believed it was going to be useful. So we had everybody, stakeholders in the room. We had about 130 people. We had people in the business. We had people from law enforcement. We had people from treatment provider services, from land management agencies, tribal interest, just everybody who was a stakeholder. And, you know, my basic rule to start out the summit was that I had an expectation that people were going to be thoughtful and civil with each other, and to there's nothing better, more exciting, more opportunity than if you get a bunch of people in the room who don't agree with each other. Some of them may not even like each other, and have an informed conversation and hear from everybody, because those are, quite frankly, all too rare opportunities. And so we did that. It was a day long, worked hard to set up the agenda, and heard from a lot of folks from around the country. I think that first summit, we had 14 other US attorneys from around the country. And then I took what everybody had to say and met with our leadership team. And in May of 2018, we announced our policy. And what our priorities were going to be. And I purposely put it in writing. And I'm pretty sure to this day, I was the only US attorney who put their policy in writing, because I felt like people needed to know and not have to guess about it. And one of my favorite conversations at the end of that first summit was when Dave came up and introduced himself and thanked me for being invited. And Dave, I don't know if you remember me noting that you said something along the lines of, guys, people from the business side of the house don't get invited to a lot of things. And I said, that's a mistake, right? So we put out our policy and our priorities. I took the Sessions memo at its word, and just developed our own policies. And you know, look, if you're in a U.S. attorney's office, you have finite resources and you've got to use them wisely. And so we focused on those areas that are outlined in the policy that you showed earlier. And that's what we focused on. And quite frankly, it wasn't all that different from what we focused on under the Cole memo, under the Ogden memo, under the Wilkinson memo, because that's what we do, right? So a year went by, and we had another summit because I wanted to know how it was going. And I will say this, in that year in between, because one of the observations being made was that the state of Oregon wasn't doing a good enough job of regulating the businesses and the black market. And by the way, the black market in marijuana across the United States, Oregon and California included, is still a bigger market than the licensed market. And I'm happy to discuss why I think that is, but it is what it is. But in that year, I cannot tell you how many people who'd given up, their life savings to try and go into the business side of things had reached out to me and saying, we're not getting enough help from the state. They're not doing enough job of enforcement and regulation, and that had to do with staffing and other things, and plus it's new. But I just found that very interesting that people just reached out to me by email, by phone, whatever. And my response was to, I would try and answer questions that I could. I couldn't give legal advice because under federal law, obviously it's illegal. But I appreciated the fact that they were reaching out. So we had that second summit, a different agenda, a different lineup, additional US attorneys from around the country. And, again, my premise in having those meetings, starting those meetings, was make it clear to people that I hope they would treat each other with respect and civility, because everyone's trying to address the developments that have gone on, the difficulties and the like. So that was my approach. I later became the chair of what's called the Marijuana Working Group, which is an advisory group to the Attorney General. I served on that committee under both administrations and then became chair. And those were important discussions as each US attorney in their own districts were trying to figure out how to handle things and work with Main Justice and advisors and the like. So, that was my approach. I like the possibilities that you can find when you have informed engagement on hard issues. And from my perspective, always, I spent 31 years in two different offices, the district attorney's office in Portland, Oregon for a decade, and a little over 20 years in the US Attorney's Office. And one thing that is absolutely critical in my view is that if you're working in law enforcement, you have to be apolitical. You can't let politics drive you. There might be people who disagree with that, but I never believed otherwise. And so part of that was just my view of how I had to approach things in a reasonable and meaningful way. And I still think, as time goes on, Congress has to decide on the question of federal law as it pertains to marijuana. And just like they're going to have to figure out for psilocybin as this moves forward, with the other states looking at passing laws legalizing it, similar to Oregon. And look, there's a lot of people, and maybe some on this program tonight, who have strong views either way. And like with all other hard subjects, I just think people need to appreciate that folks may not agree with them, and there can be all kinds of reasons for that, and strong beliefs, but it's a process, right? And it's one that has to be well thought out, because, and I'll leave my comments with this, I'm a big believer in mitigating issues in advance of them developing. And just like with the legalization of marijuana and ballot measure 110 decriminalization, there are collateral issues that are predictable and that are occurring right now. Drug trafficking organizations totally exploit what is done under anybody's law, whether it's state or federal. And drug trafficking organizations are in part international and in part domestic, and they are exploiting the circumstances and causing a lot of pain and furthering addiction to a lot of people because they don't have to pay taxes. They're not going to follow anybody's law, and they don't care about what happens to people. So I'm always asking that people keep those real facts in mind as they have these discussions. And the other part of this is municipalities who are having to assist in the regulatory and enforcement part of all of this, whatever measure number we're talking about and whatever the substance is. Those are real and identifiable challenges with collateral issues that everyone just needs to be aware of as these discussions go forward. So with that, I appreciate the opportunity.
Billy, I have one question for now. When the Sessions memo came out and repealed the Cole memo, how on your own were you, or how much discretion did you have? I assumed you communicated with the Sessions folks and coming up with the Williams memo and holding the summits, but did you have, I don't know, what kind of discretion did you have to sort of call the shots in our own backyard here?
Yeah, well, I certainly can't go into any specific conversations I had, obviously, while within the department, so I won't do that. But over time, I read the Sessions memo to give me a lot of discretion. And again, I saw it as an opportunity, and I had worked on this, subject for a lot of years as a prosecutor, and then also I've worked, for the better part of over 20 years with tribes in Oregon and in my capacities in the U.S. Attorney's Office, and then certainly with law enforcement and land management agencies. And I felt the onus was on me to just take it on. And I let folks know what I was doing. And again, I felt strongly that I needed to put that policy in writing so people knew what we were doing and why we were doing it and what those expectations were. Because that was my way of taking responsibility for the discretion that I was exercising. And if somebody wanted to, criticize me or call me out, whether it was from the public or otherwise, then so be it. If you can't handle that, then you shouldn't have that job anyway. So that was my view on it. I wasn't worried about that. I thought I was doing the right thing.
Great. So maybe we want to switch over to Jodi. Jodi, I know you did time at the DOJ and the DEA.
You make it sound like prison.
Well, yeah. Well, I should say, when I went to Billy's summit, which I was very thankful for being invited to, there was a handful of Oregon cannabis attorneys there, and it was quite the event. I mean, the Governor Brown was there at the first one. I remember she had a press in. She gave us, and I remember at the time cannabis tax revenues were doing pretty well for the state of Oregon. So she gave her staff gave this kind of rah presentation for the cannabis industry, and then she walked out of the room and the press walked out of the room, and then Billy took over the show, and there were so many folks with a lot of uniforms, more uniforms than I'm used to seeing, from a whole bunch of agencies with a bunch of acronyms that I barely knew. But it was a very really interesting day, and I think it was a civil discussion, and folks didn't agree with each other on everything, of course, but it was it was something. And I remember at one point, Billy, might have been the second one, where someone stood up and said, you know, Billy, why don't you just like shut the whole thing down right now? And I think you said something to the effect like, yeah, that's not going to happen. You know, it's just sort of like we can talk about many of the things we care about, but we're not just going to, you know, go one way 100% or the other way 100%. So, but Jodi, what do you, any thoughts you want to tell about any of your experiences? I think would be enlightening, both from a criminal perspective and a DEA registration, civil perspective.
Sure. Thank you, David, and thank you, all of you very nice people out in Oregon for inviting me to be with you. I live in Washington, D.C., and I'm admitted in New York and Washington, and I have to be frank that the psilocybin issue is not paramount or front of mind or even sort of middle of the road here on the East Coast. Like with cannabis, you folks out there are in the forefront of cutting edge, what I view as medical questions. My view, obviously not that important, and you've invited me to speak to how DEA might react to the situation when your statute becomes effective. And of course, you know, let me be clear, I don't speak for the DEA. I was the chief of staff of the agency a long time ago now, in the mid 2000s, early to mid 2000s. I did spend my career as a federal narcotics prosecutor in various guises. But my practice now does involve a lot of interaction with the DEA. And of course, I have many colleagues and friends there. So I know a little bit about how the DEA reacts to certain situations, what's important to them, what are priorities. So I will hazard a guess that DEA is not going to pay terribly much attention to psilocybin right now. I'm fairly confident that the Department of Justice is highly unlikely, for many of the reasons that Billy talked about, to require prosecutors in Oregon to prosecute as criminal cases violations of the Controlled Substances Act when conduct is pursuant to what seems to me a very detailed regulatory scheme. Prosecutors, federal prosecutors, each individual U.S. attorney in every district has discretion as to how they use the limited resources within their jurisdiction. So I'm fairly confident that we're not going to see, starting in February 2023, lots of arrests of psilocybin users or facilities or individual providers. However, DEA does have a regulatory scheme, and Kathryn touched on that a bit. One of the largest groups of registrants that there are under the DEA regime are doctors. They're called practitioners in DEA lingo. It includes physicians, it includes nurse practitioners, it includes prescribers of certain types of products, not just a local pharmacist. Him or herself is not a DEA registrant, but practitioners are. And the Oregon law sets up, a very clear conflict between federal and state law for DEA registrants. And DEA registrants, practitioners in particular, are not supposed to prescribe in violation of the Controlled Substances Act. What DEA can do, should it find that a practitioner is violating the Controlled Substances Act, regardless of state law, they can bring proceedings to revoke the license of the particular practitioner. And what this means as a practical matter for the practitioner is not just that they can't prescribe controlled substances, that that goes without saying. The way that insurers work now, hospitals work now, the DEA registration has come to be a substitute for many other regulatory identifiers. And without a DEA registration, it can hugely impact a practitioner's ability to practice even beyond controlled substances. There's no telling what DEA is going to do with regard to psilocybin. I think, as I said, it's not a priority. Fentanyl is a priority for this particular administration. The administrator who's been in role, I guess just over a year now, and her senior team have really pulled out all the stops on trying to prevent overdose deaths as a result of fentanyl. The opioid crisis remains a very big issue, but as a result of all of those litigations, those are all settling in some way or another. There are going to be monitors for the industry. The state AGs are individually going to be monitoring compliance by drug manufacturers and distributors and pharmacies. And this leaves the DEA really free to focus on what concerns this particular administrator, and that is fentanyl. What I will tell you about this administration and this administrator is that based on her background, she was a former state district attorney. She was the former attorney general of New Jersey. And she prided herself on and emphasized data and data-driven outcomes and priorities. Should information come to her attention supported by data that either it's necessary to do more research, or that this is a critical medicine that needs to be descheduled, downscheduled, or some other way of getting it out of the Schedule 1, the tightest category of controlled substances, she will listen to it, but everything will be data backed. And one little hint about DEA and where it stands on psilocybin and the importance of research to cure opioid addiction. The DEA every year puts out a quota of what companies or producers in this space can legally produce. And in the past 2 years, DEA has increased the quota for psilocybin specifically. So that's a hint. That's a change from back when I was in DEA, where the attitude was basically, sorry, we have one licensed marijuana researcher, that's NIDA with the University of Mississippi, licensed to grow, and that's it. And that's all we're ever going to do. Fast forward 20 years or so, and we see quota being given, we see licenses being given for marijuana, increased quota, and some acknowledgement that maybe the Controlled Substances Act, when it was enacted in 1972 or 3 or so, didn't adequately address all the developments in research that might come later. So there's some recognition of that. So that's a bright bit of hope. But I can't say that DEA won't enforce the Controlled Substances Act against registrants, providers like Rachel, who are registrants. The Oregon scheme allows non-DEA registrants, non-physicians, to also facilitate the giving and administration of psilocybin, and those people have much less risk than licensed DEA registrant providers do under the statute. So I'll stop there.
Well, I was going to say, Billy emphasized sort of his thoughts when issuing the Williams memo about some certainty and to be clarity, to kind of get information out there. Certainly under the Oregon Psilocybin Services Act, and I'm a business lawyer, so business folks love certainty to some degree, and we all, you know, would love to have some sort of Cole memo, Williams memo thing that would sort of give us kind of a green light and give everyone some relative safety. In Measure 109, there's one provision where the Oregon Health Authority or Psilocybin Advisory Board is obligated to reach out to the Oregon's U.S. Attorney just to sort of to have a conversation. I think literally if they had a phone call or sent an email and nobody responded, I think they would have done their obligation under Measure 109. I don't know if that discussion will occur, has occurred, or how robust it would actually be. But I'm kind of guessing, at least on the criminal side, that we're not going to have, you know, this year, before implementation at all, a flat out green light. I mean, I hope I'm wrong, and I hope we do, but I'm kind of betting that we won't. I suppose I'm also guessing that and again, hoping that there won't be a complete shutdown of the whole thing. So I'm guessing there's going to be kind of we're not going to say anything and we're not making any commitments, and we'll kind of wait and see how everything goes. And so for business folks on that end, it's a little riskier than opening up a business under the Cole memo. But it's maybe not as risky as what you're saying, Jodi, for individual registrants, because the DEA, like, again, that's their career and they can do anything administratively. So Rachel, really interested to hear what you're planning or what you're considering, and what does this give you any comfort, or do you want to run for the hills on this one?
Yeah, thank you. Well, I mean, I think it's safe to say that most physicians are pretty risk averse, as it's the whole industry. It's, a litigious place to work in general. So certainly hearing that there's no clear guidance is pretty scary to someone who would be considering practicing under Measure 109. So just to clarify, I mean, I certainly have a personal interest in potentially being, a facilitator, but I also, have a broader interest. As Kathryn said, we were on an end-of-life interest group together because there's been a lot of great research, in this population with psilocybin and, other psychedelics, and we know that there is the possibility for great impact on this population. And so on the same, or sort of in the same light, I think there's also a lot of risk to this population because these are, so I'm a hospice and palliative care physician. Right now I practice only inpatient palliative care, which means I'm seeing, acutely ill, the sickest patients in the hospital. But, there's a whole range of patients that fall under the category of palliative care, and hospice. And I know there's a lot of people in the state that have great interest in sort of protecting this patient population, both in terms of their health and in terms of their rights. And so, this is, even though the studies with psilocybin that show great promise to alleviate anxiety and depression in this population, there's also right now a dearth of research in patients who have particular conditions like the ones that I treat every day. So all the studies have been done in patients with cancer. And we know that when research is done, there's a lot of screening criteria. So the patient, in order to show, that this is safe and to show promise in terms of efficacy. So, there's a lot of patients in this population that these psilocybin has not been studied in. And so I have an interest in both making sure that my patients have access, but also that that it's done in a safe way. And so if people like myself are, not able to have any part in, in psilocybin administration to these patients, and I guess some of my questions are about sort of, minutia of, well, can I be in the room? Can I refer? Can I, things like that, and I can ask those specific questions about sort of what are the limits of where the DEA might come after someone with a DEA license. But I worry about my patient population, going to see a, no offense to anyone, but 20-year-old, yoga instructor who, has gotten their facilitator license, and they have no training whatsoever in, in medical care. I just want to make sure that, this is safe, that there is a safety net, so to speak, for these patients. So, so there's lots of different issues that I'm concerned about. And I just came from a conference this weekend where I was filling in for someone on a panel about end of life and psilocybin, and I was sitting next to the researchers who have done this work, and there's so much passion and there's so much promise, and so certainly don't want to make sure that doesn't get lost. And there's also these really real issues of both safety if patients are seeking this kind of care and don't have the proper safety net, and also for the providers that want to do this work, protecting their license and their ability to continue to care for patients and have a livelihood. So is it okay if I ask some specific questions of Jodi and Billy?
Most certainly. Yeah, ask away. Of course, Billy and Jodi aren't speaking for their agencies, and I've had occasion as a cannabis business attorney many times to ask the OLCC questions. That's our Liquor and Cannabis Regulatory Board here, and sometimes asking a regulatory agency a question is a dangerous proposition. You might get an answer, you might get the wrong answer. Sometimes it's strategically better to not ask them a question. So Rachel, by all means, ask away here. But I'm curious if someone I'm an attorney. The Oregon State Bar has, back in the cannabis days, there was a question whether lawyers who helped cannabis businesses were violating their ethical obligations. Some attorneys thought that I could, there's an argument to be made that I could lose my bar license because I'm assisting a criminal enterprise. I never asked the bar how they would come down on that. I kind of felt like I was fine. And it turned out they later on had amended their ethical rules to say it's fine. So I never felt like I was sticking my neck out. And there's nothing like that on psilocybin, but I suspect they'll have something like that. And I don't lose a minute of sleep over it. But Rachel, it seems that things are much more uncertain here. So would you ever, and Jodi, maybe you can give your opinion on, if Rachel called up the DEA and said, hey, I'm interested in maybe doing this, how would you react to that? Would that be a smart thing to ask the DEA in the first place? Would the DEA answer or stare back blankly, or how would that go down? Or, yeah.
So, I mean, DEA just doesn't give advisory opinions. Some agencies have advisory opinion processes. DEA does not. I think it would be unusual for Rachel to even get an answer, unfortunately. There is a liaison and policy office. that is better at answering than some other places within DEA. The answer would not be, I think it wouldn't be definitive or necessarily reassuring. It would likely quote what the law is. Some lawyers might tell Rachel, don't identify yourself to the DEA. If you're doing this, you're putting a target on your back. I don't know that those kinds of, and this is from coming from inside the agency, right? They wouldn't have a liaison and policy office if part of that office's job was to take legitimate industry questions and refer them over to the license monitors. So I'm not sure that there's a risk in asking the question. I am fairly certain that you would not get a definitive answer if you got an answer at all. Because I think at that headquarters level, the agency wouldn't want to take a position that might be fact specific, might be fact driven, and probably didn't take the time to really think about it. So I don't think that there would be an answer, but I'm not sure I would worry about the risk of asking. And I'm one of those lawyers that advises my clients that it's better to know for sure if you can get an answer than just hope for the best. If I had a cannabis practice back in the day, I would have been one of those attorneys who reached out to the bar and said, am I violating my ethical obligations? Luckily, New York decided that I wasn't before I ever asked the question. But I don't think it hurts to ask. You won't get an answer. And that is sort of just where DEA is. They're loath to jump in the regulatory arena, except through Administrative Procedures Act processes that are very well defined.
Well, I am not planning on calling the DEA to ask them any questions. And I guess I will say, just in case the DEA is listening, unless I was given like a very clear, you are protected under this, statute, like I have no plans to practice under Measure 109 in this way. But it's interesting at the conference that I was just at, one of the things that was being discussed was sort of the oversight of the sort of psychedelic practitioners themselves, and ethical issues and training and licensing, et cetera, et cetera. And one of the in the field who's developing a facilitator training in Oregon showed a breakdown of the people that had applied for his program to become a facilitator, and it was very varied. And there were several MDs, there were other licensed professionals, and I have a question about that as well. And my question, is I wonder if those people are wanting to become trained as facilitators in the expectation that one day down the road, psilocybin will be federally, rescheduled, or, are they not thinking about these issues because they feel like they're protected under the Oregon law? I'm not sure. But, that was sort of proof to me that there are certainly people in my position that are pursuing this training, and whether they're thinking about all these issues, I don't know. But and I don't know if you can speak to this, because I know we're talking specifically about DEA licensure, but the other people that I imagine are the best qualified to do some of this work in Oregon, even though this is not a medical model, there's certainly going to be people with severe mental illness who are desperate, who've tried everything, that's been prescribed to them, or therapies that have been prescribed, and so are seeking out psilocybin. And there's a lot of risk to them to not, if it's, you know, if they have a history of trauma or, you know, other forms of illness that that really takes very, you know, specialized and specific types of care. I'm curious if there's also been discussion about, you know, what, you know, not just DEA, and I know specifically we're talking about DEA, but I just wonder about other sort of professional licenses. And if that's something that you all are thinking about and talking about as well.
Rachel, do you mean like state licenses? Because yeah, I mean, you know, there's a lot of state license holders who are interested in participating. So who don't have DA registrations, like psychologists, for example. And just like I was sort of concerned with my state license, I suspect that if I was a psychologist, that had nothing to do with the DEA registration, I might wonder whether the Oregon Psychology Board would frown upon me practicing psychology in conjunction with facilitating psilocybin services. And in my mind, that's just an issue, that's a state law issue for the board to consider. The Oregon State Bar could have certainly said, we don't want you to do this for legal purposes. So, and I don't know if the state, now, you know, the Psychology Board is itself a creature of state law, as is Measure 109. So one would think to some degree they would sync up, but on the other hand, the practice of psychology is its own thing. And one, I suppose the folks in charge of that board would say, well, you know, is this new thing that's happening here, is that consistent with how we view the practice of psychology under Oregon law? And I suppose they'll make a decision, but who knows? It seems like nobody makes decisions up front. Like everyone will sort of wait and see, and then figure out what will happen after that. But you know,
I mean, I'll jump in and say, related to that topic, Dave, that I think that this question of what are the various licensing boards, what position will they take about their licensees participating, is an open question. And I think that it is timely to be having conversation about preparedness to be able to respond to investigations or disciplinary proceedings that these different licensing boards may launch against their licensees. And I've had some discussion with that on that topic recently. And I think being prepared to be able to respond to those investigations is important. And, you know, normally what those licensing boards will be wanting to understand is whether the care that was provided by their licensee was within standard of care. That's kind of their benchmark. And so what we have here is a very new modality, but it's not a modality about which nothing is known, right? So there's a tremendous amount of knowledge that's been developed in various places, including in the recent clinical trials and including these different training modules that outline, you know, what is appropriate for provision of this service. So I think there will be possibly some of those investigations, but I would hope that nobody would end up with a serious sanction for participating in an act that's made lawful by the state, so long as they could point to evidence that they were within a standard of care. And of course, that's informed by a lot of things.
So this direct conflict between state law and federal law is very interesting. Billy, I was often asked by folks investing in a cannabis business, for example, can I go to jail? I'm just investing, or I'm just doing this or that. Can I go to jail? And we, of course, would disclose to investors the Cole memo or whatever memo was in place at that time. And we would say, yeah, you could go to jail, your property, your company's property get seized, all of that. We give them this like litany of horror stories that could happen to them. And then they would say, but really, really, Dave, am I really going to go to jail? And I would sort of have to disclaim everything. I'm just a business lawyer. And I would say something like, well, just, I'm not going to put this in writing, but one would think that if the feds were going to come on in and change their minds, that they wouldn't, out of the clear blue night, come in and start arresting people like just without warning. But like there would be some semblance of order, and they might say like, look, we gave, we're revoking this memo, or we sat here and we looked at how this thing unfolded, and we were willing to sort of give it a chance, but we're not liking what we see, and now we're going to tell you all to we're going to talk to the state and talk to the legislature, but we're shutting this thing down, and everybody has until 10 days or tomorrow at 5 p.m. or something to like stop it, but they're not just going to randomly arrest everybody. And that seemed to, even though it was not in writing, and even though I didn't know what the heck I was talking about, that just seemed logical to me. Now, I don't know on a registration thing, and I felt similarly with the bar. I'm like, well, they might tell me to stop doing something, but I don't think in such a weird state, almost a unique issue, they're just going to come in and yank my license. So, Billy, was there any, and you don't have to answer this, but like, did that ever happen? Everybody knows right now. I mean, maybe Jodi, no one's paying attention to it in DC, but I suspect that the U.S. attorney in Oregon has heard of Measure 109. It's a state law that was passed, and I suspect somebody's paying some attention to it. And I suspect that they're probably going to do nothing. But would they ever wake up in the morning and say, we don't like what everyone's doing and we're going to arrest everybody? Or would there be more order to it, in your hypothetical opinion?
Yeah, that's a good question. Look, what the current administration or any other administration decides to do is going to be influenced by, for instance, whether or not Congress has done anything, and what is what is the lay of the land. But I would say this, the reality is people make decisions at their own risk, right? And choose to engage in conduct that puts them at risk. And some people think that through better than others. But I can't answer the question about, what's the current administration going to do. It was my experience in over 20 years with the Department of Justice that whatever administration was in office, and whoever the Attorney General and Deputy Attorney General was at the time, decisions are thought through and discussed, and that's just the way it is. I always found it to be fairly methodical and thoughtful. Doesn't matter what administration was in office. So I look, there's always a risk if you're doing something that's not in compliance with either state or federal law, or both, one or the other. But I just can't, I can't answer for, it does, pose some questions, just the status of things and where it's at. I was reading in some recent articles in preparation for this afternoon's program, and there was an article that the author had interviewed a variety of business interests, and those who, from all appearances, have tried to have influence on the Oregon Health Authority and the advisory report. And then there were some who were looking long-term at if Congress changes this, or at least here in the state of Oregon, since this is where it's been state legalized. And there was one business proposal that, they were going to be, their idea was to open up like a facility where people could come in the morning, and it just cracked me up the way it was described as a new morning ritual that in place of coffee, people would go to a cafe and eat a small amount of magic mushrooms, perhaps combined with yoga or meditation. And that's interesting, but I was thinking, so how does this impact people making decisions on, developing the regulatory framework? And was this the real intent of ballot measure 109? And I pose this because, from my reading of 109, it doesn't seem to be in line with what the purposes was, but this is where sort of the balance of concerns has to include people from this description. It's like undercutting the original intent of measure 109, right? So those are the kinds of things that I think will tend to influence decision makers about what is this program really doing. It's like the people involved in the industry, the cannabis industry, and the hemp industry, and people who are exploiting those two programs to feed into the black market for whatever reason, right? They don't have to pay taxes. That undercuts whatever credibility you're trying to reach in terms of the license program. So I mention this because this plays into those kinds of discussions and decisions that are going to be coming on this subject that I think, certainly have the potential to sway opinions and policymakers on what to do. Because again, at some point, the administration and Congress is going to have to figure this out.
And,
I being a lawyer, I still believe in the supremacy clause of the U.S. Constitution and the case law that's followed, and that plays a role in a lot of discussions, right, from a legal standpoint. But this is such a still formulating area, right, being developed and everything, and all of these questions the questions from Rachel are so important to practitioners who, and just Dave, like the questions you ask yourself about licensing with the bar, people have to answer those questions themselves if they're not sure if it's legal or not.
Question, which I imagine that there was some, precedent related to when this was all happening with marijuana. I think at some point, probably physicians were worried about even discussing, marijuana with their patients when they were asked, for fear of, for prosecution of aiding and abetting, or, and I'm wondering if there's been similar discussion in this area, so it's very clear that, my DEA license is not protected if I'm a facilitator and I'm giving marijuana, psilocybin, but what if I have patients that just ask me about it? Or what if I have a patient who, I think would really benefit and this is available?
Well, the good news there, I do think we have the answer there, and that's in the Conant precedent, where it's clear that physicians do have freedom to communicate with their patients about a therapy that they think might be beneficial. That is protected speech, and that was the Conant decision. I think that was on one of our slides. But what I think seems really unfortunate is if you conclude as a clinician that this therapy would be beneficial for your patient, and you have a patient who's with advanced illness and could benefit from receiving that therapy from a skilled medical provider that understands how to provide care to that unusual population, that you would feel that you couldn't do that. And that's the real challenge here.
Not unless I start a research study.
Yeah, well, and of course, we're talking about therapeutic use. And so, to try for the DEA to try to drive everyone into research is really inappropriate. And, not to go off on the tangent, and maybe we'll do a deep dive into how federal safe harbor might arise under right to try, which could enable physicians to feel safe because there would be a federal safe harbor. On a different deep dive, but that's why we're pressing so hard to have the DEA respect already enacted state and federal right to try laws that would apply to psilocybin for this population.